Welcome back to Court, the series where legal buzzwords stop being abstract and start being tested where they actually matter in front of a judge. Today, we return to Harris County Criminal Court in Houston, Texas, where Judge David Flisher is once again doing something that shouldn't be remarkable, but somehow is. He's asking whether the state actually met its burden before dragging someone deeper into the system. This episode focuses on a set of probable cause hearings where the answer, repeatedly, was no. Probable cause is often treated like a rubber stamp. An accusation gets made, paperwork gets filed, and the case rolls forward as if momentum itself were evidence. But that's not how the law is supposed to work. And Judge Flisher's courtroom has become a rare place where that principle is enforced instead of ignored. Each hearing we'll cover today shows what happens when a judge slows things down, strips away assumptions, and demands articulable facts instead of vibes, instincts, or hindsight rationalizations. This series exists for one reason: to show how probable cause actually functions when it's evaluated by a neutral decision maker, not when it's glossed over to keep the docket moving. And if there are specific probable cause hearings you'd like us to break down in future episodes, let us know in the comments. Now, let's start with the first case. On February 21, 2025, Edward Love Jr. and Edward Love III were charged with evading arrest or detention. The allegation was simple on paper. When a police officer approached them, they ran. A probable cause hearing was held 1 week later, on February 28th, in Judge Flisher's courtroom. And, as we're about to see, the difference between running from police and not being lawfully detained in the first place is where this case begins to fall apart.
Michael Love, come up.
It's two, Michael Love and a Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's Junior? And you are? The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officer dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary in progress, with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both contained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, sir.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, what is this, Minority Report? You know what I mean?
I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand? Sir. I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Judge Flisher doesn't take long to cut to the core issue. Under Section 38.04 of the Texas Penal Code, evading arrest isn't about movement. It's about intent. And intent only exists if the officer is lawfully trying to arrest or detain someone and the person knows it. That knowledge doesn't appear by magic. It has to be communicated. In this case, there was no command to stop, no verbal directive, no signal that either Edward Love Jr. or Edward Love Athur was being detained or arrested. Without that moment, the clear transition from casual encounter to lawful detention, the statute never activates. You cannot flee from a detention that was never initiated. Judge Flischer makes that distinction explicit. The absence of a communicated attempt to detain means the essential element of intentional flight simply isn't there. And when a required element is missing, probable cause collapses with it. The result is immediate. The state dismisses the charges the very same day, and that timing matters. It shows what happens when probable cause is treated as a legal threshold instead of a formality. Cases don't linger, and people aren't forced to defend against charges that were never legally viable to begin with. With that interaction resolved, we move on. The next probable cause hearing in this episode takes place on April 14, 2025. Just 3 days earlier, on April 11th, Nicholas Kubler was charged with a second, offense driving while intoxicated. And this next case raises a different question. Not about commands or communication, but about what the state claims it observed versus what it can actually prove.
I had a guy charged with a felony that was arraigned this morning, but he's on your docket later in the week, and I was hoping just to get it done so we can.
Of course, let's do it.
Okay.
Do you have the cause number?
I do, 255-9578. He's already got conditions from Judge Simons. Where'd he go?
Judge Simons.
Yeah,
Okay.
Judge E. Simons. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Kubler.
Kubler, yes, sir.
Kubler. Mr. Kubler, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I see. So that he's also charged with abandonment. Is it out of the same transaction?
Yeah, we had a long discussion with him this morning.
I don't know anything about it. Let's find out what's going on, please.
On April 11th, 25, an officer was dispatched to an unknown incident or accident, excuse me, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tires, skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the complainant, and then it said the damage to the Jeep was probably $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed an exit vehicle from the driver's side door. Upon exiting the vehicle, the wheel witness observed he was not stumbling, and then the wheel witness observed slurred speech and strong odor of alcohol beverage emitting from the defendant's breath and personally. The defendant also admitted that he was trying to flee the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed, sorry, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
I'm sorry, he did not. He did not. I apologize. We can just have just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these, like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really,
Trying to see if I can find anything else.
case after case, we're just,
So Judge, things don't say it, don't say or is the results of those van revealed sobriety tests, and we do not have an officer.
how on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I Don't say. I don't know why it's not in the DIMS. Obviously, we didn't write it here. We represent what is written in there. And so I understand your frustration. I'm highly frustrated.
Mr. Kubler, I'm gonna find no probable cause in your case. Don't kill anyone. You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. Now, this is not to say that they may not indict this case at a later time, but whatever, just don't kill someone, please. Take a seat, please, sir.
Judge Flischer's next ruling exposes a problem that shows up far more often than it should, the state relying on paperwork that simply doesn't do its job. This finding turns on the DM's report, short for the District Attorney Intake Management System. In Harris County, this is the document generated when an officer submits charges for a warrantless arrest. It's not supplemental, it's foundational. The District Attorney's Office relies on that report to establish probable cause before a case ever moves forward. According to the DIMS manual itself, the report must contain a factual summary detailed enough to demonstrate each element of the alleged offense. In this case, it didn't. Judge Flischer finds that the arresting officer's DIS submission was thin to the point of failure. The allegations lacked sufficient factual detail to support probable cause, and without that threshold met, the court had no choice but to reject the charge. But here's where the case takes a turn. On May 23, 2025, the state filed a new complaint stemming from the same arrest. This time, prosecutors charged Mr. Kubler with felony third offense DWI after identifying a second prior conviction. 4 days later, on May 27th, the original second offense DWI charge was formally dismissed. As of now, the felony charge remains pending. The takeaway is clear. A weak intake report can kill a charge. But it doesn't necessarily end the prosecution if the state later finds a stronger path forward. From there, the court moves on to another probable cause hearing, this one taking place on April 4, 2025. Jonathan Cerna was charged days earlier on March 29th with interference with public duties. Officers were executing an arrest warrant for a felony murder suspect outside Mr. Cerna's home. According to police, he was instructed to remain outside while they secured the area. And when he allegedly refused, he was arrested. What matters next isn't the seriousness of the underlying warrant, but whether the command given to Mr. Cerna was lawful, clear, and enforceable. And once again, probable cause turns not on authority, but on precision.
$2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, sir.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there. Stop. Oh, sorry, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
Ordered him to stop. He refused. Jim stopped going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was, if service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's been this specifically.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer in Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him off balance and took him to the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary, and I'm going straight from the Dems now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I don't think
I'm gonna find no probable cause in your case. Just be careful, man. When you get into a pissing match with
I understand.
who's gonna win,
They are.
Judge Fleischer's ruling in this hearing draws a hard line between police authority and actual criminal interference. And the state came up short on the evidence. The charge at issue was interference with public duties under Section 38.1 of the Texas Penal Code. To sustain that offense, the law requires more than simple noncompliance. The state must show that a person actually interrupted, impeded, or disrupted an officer who was lawfully performing their duties. That distinction mattered here. Officers were executing an arrest warrant for a felony murder suspect outside Jonathan Cerna's residence. Mr. Cerna himself was not the subject of the warrant. According to police, he was instructed to remain outside while the arrest operation was underway. When he attempted to re-enter his own home, officers arrested him and charged him with interference. But Judge Fleer wasn't persuaded. There was no evidence that Mr. Cerna threatened officers, blocked their movements, entered the arrest zone, or compromised safety in any concrete way. The officer's attention remained focused on the suspect outside, and nothing in the record showed that Mr. Cerna's actions meaningfully disrupted that operation. In other words, the command may have been issued. But the state failed to show that disobeying it actually interfered with police work, which is a required element of the offense. Without proof of real obstruction, inconvenience alone doesn't rise to criminal interference. Judge Fleer found that the statutory threshold simply wasn't met. As a result, the court entered a finding of no probable cause, and the state dismissed the charge the very same day. This ruling reinforces a critical point. Not every police instruction carries criminal consequences, and not every refusal becomes a felony. The law demands evidence of interference, not assumptions of authority. With that case dismissed, the court moved on to the final probable cause hearing of the episode. On April 25, 2025, Joseph Ramirez appeared after being charged 1 week earlier on April 18th with driving while intoxicated.
jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knees. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol. There's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's just going to, so that's the odor of alcohol.
Like, come on, man.
That's what, no, that's, I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge, but I've never had it.
You're killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Okay, yeah,
That's
That it?
all we have before we initiated the standardized post-mortem test.
okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears. You know,
So,
we have enough death on our streets now, you know, $40.
Judge Flischer's final ruling in this episode brings the entire theme of these hearings into sharp focus. Constitutional standards are not optional, and probable cause is not something the state gets to fill in later. Joseph Ramirez was charged with driving while intoxicated, but when the court peeled back the layers of the arrest, the foundation was alarmingly thin. The officer's justification for escalating the traffic stop rested on a single observation: the alleged odor of alcohol on Mr. Ramirez's breath. No swerving, no unsafe driving, no glassy eyes, no slurred speech, no balance issues, no admissions of impairment, just a smell. And in Texas, that is not enough. Texas law draws a critical distinction that often gets ignored in everyday policing. The statute does not prohibit driving after consuming alcohol. It prohibits driving while intoxicated. That difference is not semantic, it's constitutional. Before an officer can lawfully request field sobriety testing, they must have reasonable suspicion that the driver is actually impaired, not merely that alcohol may have been present at some point. Judge Flischer made clear that reasonable suspicion requires articulable facts pointing toward intoxication. The odor of alcohol standing alone does not satisfy that standard. People can smell of alcohol for countless innocent reasons, and the Constitution does not permit officers to convert that ambiguity into an invasive roadside investigation without more. Because that threshold was never met, the field sobriety tests were unlawfully requested. That single misstep set off a chain reaction the state could not recover from. Under Article 38.23 of the Texas Code of Criminal Procedure, evidence obtained through a constitutional violation must be excluded. That exclusionary rule is not a loophole. It is the enforcement mechanism that gives constitutional rights real meaning. When the initial request for sobriety testing was unlawful, everything derived from it became tainted. The field sobriety results were suppressed. The subsequent blood draw was suppressed. And once that evidence was stripped away, the state had no remaining basis to claim probable cause for the arrest. Judge Flischer therefore entered a finding of no probable cause, and the prosecution dismissed the DWI charge the same day. When viewed alongside the other hearings in this episode, a clear pattern emerges. In one case, officers failed to communicate a lawful order before alleging evasion. In another, the state relied on a DM's report that omitted the very facts required to justify an arrest. In another, officers attempted to stretch an interference statute beyond its legal limits. And here, an officer relied on assumption rather than evidence to escalate a routine traffic stop. Different facts, same outcome. Probable cause cannot be manufactured after the fact. It cannot rest on incomplete narratives, misapplied statutes, or evidence gathered through unconstitutional shortcuts. Every charge, whether minor or serious, must stand on competent, lawful evidence that satisfies the elements of the offense. Judge Flischer rulings serve as a reminder that courts are not rubber stamps for arrests. They are constitutional checkpoints. And when the state fails to meet its burden, dismissal is not a technicality. It is the system working exactly as intended. These cases reinforce a fundamental truth: the rights of the accused do not yield to efficiency, convenience, or assumption. Judicial oversight remains one of the most important safeguards in the criminal justice process, ensuring that liberty is not taken on less than the law requires. If there's a case or courtroom interaction you'd like us to examine next, let us know in the comments below. Thanks for watching. And don't forget to like and subscribe so we can continue building a more informed society.